Good morning and welcome to the authors panel discussion. And congratulations to all of you for making it to the international rounds of the Jessup Moot Court competition here in beautiful Washington, D.C. Congratulations, everybody. My name is Gabrielle Goodwin, and I am the Assistant Dean for Graduate Programs and Global Engagement and a Senior Lecturer in Law at Indiana University Maurer School of Law. It's an honor for Indiana Law to sponsor this authors panel for the third year in a row. And this event gives you a unique opportunity to hear from the authors of this year's problem and to maybe get an answer or two to some of your most burning questions. In addition, Indiana University is now the host and proud co-sponsor alongside ILSA of the inaugural undergraduate Jessup Moot Court competition. In exactly 12 days, dozens of undergraduate students from colleges all around the United States will be descending on our beautiful Bloomington campus to convene at our sister school, the Hamilton Lugar School of Global and International Studies, to participate in an exciting competition, the first of its kind. These undergraduates will have the chance to moot the case concerning the Order of the Opal and gain valuable skills that could assist them in participating in the actual Jessup in future years. Both of these events and our investment in them demonstrate Indiana University's long-standing commitment to international law, to moot court competitions, and to the Jessup. As the Dean of Indiana Law's graduate programs, which includes the master's and doctoral degree programs, I travel to law schools all over the world, meeting with students, faculty, and alumni. Over the last few months, in every country that I visited, I've watched as students struggled with and prepared for this year's competition, trying to make sense of a complex problem concerning maritime boundaries in the face of climate change and sea level rise, government recognition at times of political turmoil, sovereign immunity over foreign state assets, and the prosecution of government officials for international crimes. I met with applicant students who tried to find ways to defend Ambrosia's fixed baseline law, and respondent students who explained to me why it was utterly proper to seize the Falcon and employ universal jurisdiction charges against the enforced disappearances program carried out by former Minister Cross. These are serious and incredibly relevant issues today, and the world needs more highly trained legal professionals with expertise in these areas. At Indiana Law, we've had the privilege of teaching students from all over the world, from India, from China, from Myanmar, from France, from Italy, from Colombia, Brazil, Nigeria. Every class, every year, has between 25 and 30 different countries represented. Our faculty also bring diverse and important international legal perspectives. Our dean of the law school, Christiana Ochoa, studies the fields of business and human rights, law and development, and international finance. Our former dean and colleague, Hannah Buxbaum, is a world-renowned expert of private international law and international litigation. My own research involves international cultural heritage law and policy, and in just a moment, you will meet my colleague, Professor Asaf Lubin, whose areas of expertise include cybersecurity and national security law, intelligence regulation, and international human rights and humanitarian law. The Masters of Law program, the LLM program at Indiana Law, offers a number of specializations where students can choose to focus their studies on international law and how international law intersects with other subjects, such as cybersecurity, information privacy, intellectual property, financial regulation and capital markets, business and commercial law. Moreover, students who complete the LLM program may be eligible to sit for a bar exam in the United States, and we currently have a number of our alums practicing here in the US. Much like the Jessup competition, which is a one-of-a-kind experience that nurtures students' interests and prepares them to engage with the global legal profession, the LLM program at Indiana Law also is unique in that it offers a high degree of specialization and opportunities for students to choose their own path, fully supported by a world-class and globally engaged law school. To learn more about our programs, I invite you to pick up a brochure or business card on the table in the back. I'll be here myself after the panel discussion if you have any questions. Now, I will excuse myself and cede the floor to Dr. Asaf Lubin, Associate Professor of Law and Faculty Affiliate at the Hamilton Lugar School of Global and International Studies, and the moderator of today's panel. Thank you.
I'll be remiss in not saying just one sentence about Indiana University. The amount of money and effort that the law school spends on supporting this program year after year, and then supporting ILSA in other ways, is just reflective of the kind of law school that gets it. And I'm just eternally grateful for the fact that they're listening to me, honestly, in making these connections possible. And so if you ever consider a law school, and there are many law schools to choose from, many great law schools to choose from, just know that. All right, that's it. That's all the advertisement you're going to get. So I'm delighted to be here. My name is Asaf Lubin, as was said. I have been involved in this competition for the last 14 years. First as a participant in 2011, and then as a coach, and then as a national administrator, and then as a judge. And I authored a problem in 2016 and authored a problem again in 2023. And I've been involved on the editorial committee helping authors draft their problems, including these amazing authors who have drafted this amazing problem for you for this year. And so my job is to be quiet and not say much, just to allow them the chance that they so immensely deserve to be congratulated by all of you for what they've done. And so before we even do anything else, please join me in giving them a huge round of applause. The work of drafting a Jessup problem is a thankless one. You spend hours on end fighting with an editorial committee of many, many people who disagree with you on literally every aspect of the competition. It often is frustrating. You have only your peers to try and give you some remorse at times when it gets really, really hard. The moment, and most importantly, you don't get compensated for it. The only thing that makes this valuable is the realization that you've helped support a legacy, and you've helped inspire dozens and dozens of students all around the world in thinking about some of the world's most important legal issues. And this year is no exception. There is a third author who is unable to join us, so I wanted to start by acknowledging their presence, and that is an author you might know because you might have read his work, and that is Nico Pavlopoulos. That's what I thought. So Nico is an associate legal officer at the International Court of Justice, and he is the author of the Oxford University book, University Press book, The Identity of Governments in International Law. With that said, I will now turn to our two other authors to, what I've asked them is to introduce themselves to you, and then say a few opening remarks. The majority of our time together today will be spent with you leading the charge. Finally, we reverse the turns. It's not us as judges asking you all these hard questions. Instead, it's your turn to ask us hard questions. So you'll just come to that mic in the middle of this room and ask our authors questions. Everything is on the table, and you're allowed to ask just about anything. But before we do that, let me give Ben the floor.
Great. Hi, everyone. Thank you for being here. My name is Benjamin or Ben Salas. I am a national from Chile. and I am the special assistant or principal legal advisor of the president of the International Court of Justice. So I've spent the past 2 years working at the court, now with President Iwasawa. And before that, I worked in several cases before the ICJ. I worked first for the government of Chile in cases against Bolivia. Then I worked in cases for Somalia against Kenya in maritime delimitation, the DRC, Uganda cases for Uganda in the reparations phase. And I previously worked for the government of Chile as the foreign policy advisor to the president of Chile for 3 years. And yeah, now I'm at the court. So it's quite special to be here because actually for me and Janina, for both of us, it's the 10th anniversary of the year that we competed in the Jessup. So we both competed in 2015 and it was quite special for us to be able to author the problem 10 years after we competed. It's actually my first time though attending this breakfast because 10 years ago I was preparing for the final round, which is going to take place at 2. So this is all very new to me, being on this breakfast. So I wanted to share a couple of general thoughts of what inspired us to create this case. And one of our first thoughts was that we wanted to involve core issues of international law and international dispute resolution, and we wanted to avoid getting to very niche areas of international law, but rather go to the very fundamentals of international law. And even though sometimes the topics might have seemed as if you were drifting into very specific areas, what we really wanted to was to go back to the basics. So that's why we decided to have an issue on questions of jurisdiction, which is essential for everyone that wants to practice before an international court and tribunal. Knowing how the court's jurisdiction works is essential if you want to be a good international lawyer. We also wanted to tackle some of the fundamental issues that are currently being very debated in international law, and that's why we wanted to choose universal jurisdiction on the question of immunities. The question of immunities is right now being debated in the International Law Commission. Just a few weeks ago, the second report of the Special Rapporteur was published. So we really wanted something where the law is not clear and you can actually participate in the shaping of international law in that area. Of course, for me, it was also significant that the Special Rapporteur is from Chile, Claudio Grossman, so that also had an additional flavor. And then we wanted to have a pleading about the interplay of the sources of international law, right, which was pleading 3. So to students to think about how treaties and customary international law relate to each other. A lot of times we deal with treaties, we deal with custom, but we don't have many occasions to really think deeply about how the sources under Article 38 of the statute interact with each other. And that was the very essence of pleading 3. And finally, pleading 4, we wanted to have a topic that was politically relevant, where people working in governments have to constantly deal with. So it's a very practical issue where there's not a lot of law about it, but it is a reality that international lawyers, especially people working in governments or advising governments, have to deal with. So that was a bit of our way to kind of bring these issues together. Now, the second thing that we had in mind was we didn't want to have 2 states where one was the good guy and the other one was the bad guy, which is a very traditional model that previous problems follow. So here you don't have either a good applicant and a bad respondent. So we try to follow a different scheme. And we have 2 states that actually get along with each other regularly. When the issue of the baselines arose, they sent each other diplomatic notes. They didn't, start threatening each other. They followed the usual diplomatic conduct. The seizure of the airplane was linked to domestic proceedings. It was not a head of state ordering the seizure and selling of the official airplane. And then when you had, the issue of the arrest of Ms. Cross, also again, we reverted to the usual diplomatic channels of issuing note verbals and so on. So the idea was how to have 2 states which are more regular in the international community in the sense that they do get along, but how that can actually turn into a controversy. Now, Asaf told us that we should say some things that impressed us from the oral pleadings, that we definitely did not think about, and we were quite surprised. So for me, one of them was the amount of time some teams spent talking about fish. So the fish here were completely irrelevant. There was no need for any teams, or we did not at least expect any teams to go deep into, analyzing what the fish were, or the second is that we saw a lot of teams invoking maritime delimitation, as if there was an issue of maritime delimitation involved here. And the issue of freezing of the baselines is not an issue of maritime delimitation, as usually comes up in contentious cases before the court. So that was also quite surprising when they would try to bring rules of delimitation into this case. And another thing that always surprises me, and this goes beyond being the author of this year, is the liberty with which eminent publicists are quoted by students. You have to be careful. I mean, the court has never made reference to publicists in its decisions. So if you're going to quote someone and claim that it's an eminent publicist, you have to be very careful about who you're quoting. Try to find always a case. It's better than doctrine. Then Asaf also recommended that we, share some of the names or ideas or kind of how we came up with the characters in this story. So Mary Zavala was my co-agent in 2015. She's very happy living in New York. You might have seen her in the US regional rounds, and I think she may have come here for some of the preliminary rounds, but she was definitely on the US regional round, so that was in honor of her. Also, there were other team members involved. Alex Foyt, the chief of staff of Zavala, was my coach in 2015. Badia Airlines is also after one of my other team advisors. The Kingdom of Red Sea is the nickname of my youngest brother. So that was also a family reason there. And Ambrosia is my favorite restaurant from Santiago in Chile. So it's Ambrosia in Spanish, and so the name should really be Ambrosia, but of course Ambrosia is the. And then a final word, and then it's all to Janina. I just wanted to talk about a little bit about what you can pursue as a career in public international law, and particularly in the International Court of Justice, because I imagine that, at least when I was there a decade ago, I would dream about a career in international law, and especially about the possibility of one time in my life working at the ICJ. And the International Court of Justice has a great program called the Judicial Fellowship Program, which is a 9-month internship program where you work with one of the judges of the court full-time alongside the permanent clerk of that judge for a period of 9 months. You have to apply through a university, so it's a university-sponsored program, so you have to first internally be selected by your university, and then your university puts you forward as the candidate of that university to be selected by the court. There's now a trust fund. So universities from countries that are part of that trust fund, which essentially includes the entire Global South, can benefit from a trust fund that will cover all of their expenses for 9 months. So if you're studying at a university which you think it's extremely difficult for that university to sponsor you, you can apply to the trust fund and therefore get the court to pay for the 9 months that you're going to spend there working with one of the members of the judge. Members of the court. So I really encourage you, if you're interested in pursuing careers in international law, talk to universities back home, inquire whether they have previously participated in the Judicial Fellowship Program, and if not, try to participate. Both of us have worked with amazing judicial fellows. I know that there's a couple of former judicial fellows also judging this year, and which are here in this room, and spending 9 months as a young practitioner or young scholar at the court, working alongside one of the members of the court is a fantastic opportunity. So I really, really encourage you to consider that option. Thank you, and Janina, the floor is yours.
Thank you so much, Ben and Asaf. Good morning, everyone. Thank you so much for coming to this event. I imagine that all of you must be very tired and exhausted from the competition, and we are very much looking forward to actually talking with you about this case that kept us busy for more than a year, actually, and that developed a life of its own that we wouldn't have expected. And so we're very excited, I think, to talk with you about it. Perhaps a couple of words about myself. My name is Janina Barkholt, and until recently I was working at the International Court of Justice as an associate legal officer, so as a colleague of Ben and also of Nico. I started as an associate legal officer in 2021, beginning of 2021, so at the peak of the pandemic, which was a very special time in The Hague. The court was rather quiet at that time. But then the entire dynamics changed, and the court became quite busy over the last couple of years. Actually also including the time when I left the court at the end of last year. During my time at the court, I was working for Judge Nolte, the German judge, and I'm also German by nationality, and also for a couple of ad hoc judges, including Judge Kress and Judge McRae. Before that, I was an assistant at the International Law Commission for 6 years, from 2014 to 2021. And this is also one thing that I would warmly recommend you to have a look at. I think I mentioned it in a couple of rounds in the feedback session afterwards. There is now a call for applications to become assistant to the International Law Commission, and this is unprecedented so far, and I encourage all of you to consider this opportunity. I think this was one of the fantastic opportunities that I got to work at that time, especially as an assistant for the International Law Commission, and also on topics that you might be very familiar with now, that is especially subsequent agreements and subsequent practice. As some of you might know, Judge Nolte was at that time the special rapporteur for that topic, and I was assisting him in some of the years on that topic. But also the issue of immunity of state officials was on the ILC's agenda, and still is on the ILC's agenda, and was discussed during those years. In particular, also the very special session of 2017 when draft Article 7 was debated, very hotly debated, one might say, and that also inspired the parts of this year's problem. In addition to that, the sea level rise issue made it to the ILC's agenda at that time as well. So many strands of the substantive issues in this year's problem actually came together at that time. Right now I am going back to academia. I'm currently a visiting scholar in Paris and a postdoctoral researcher at Freie Universität Berlin. But as Ben already mentioned, I was also a Jessup participant in 2015, so 10 years ago, and it is very special to be here 10 years afterwards and discuss the problem with you, and also to share a couple of impressions of the whole process of writing this problem with you. As Ben already mentioned, there were a couple of considerations that led us to this year's problem, in particular also the importance of jurisdictional aspects, especially when you want to practice before the court at some point, or on issues of general international law as such. But what we were also thinking once we found out that all three of us were participating in Jessup in the same year was that we wanted to reflect both contemporary issues but also more perennial aspects of international law, so sources, but also some of the more pressing issues that are currently on the agenda, such as sea level rise and climate change. So at some point when we found out, we got together, and I still have these wonderful memories. I think, Ben, you might share them as well, when we sat together in the cafeteria of the court, and it was spring, and we were sitting there thinking about how to put these issues into a narrative, and that was actually one of the aspects that was most challenging, but also most fun, I would say, to find a way to create a story out of law, in a sense. And perhaps some of the Easter eggs in the compromise from my side. So I also tried to put my co-agent from 2015 into the fact pattern, because I mean, all of you probably by now can relate to the fact that you become very close in the team and you really become this community of destiny in a way. And for me, my co-agent was a very special person as well. So the law firm Klein and Schäfer is her, because she got married in the meantime and changed her name. So that's why there are two. But also Arn Hill, the capital, is actually my hometown in Germany. It's a very, very small town. Nobody knows it. And it's called Arnsberg, but the Berg is in English hill. So I try to, as Ben, pay homage to my hometown there as well. It's very boring, but it's also quite beautiful. Gertrude Cross is inspired by Gertrude Bell, who was a female explorer around the beginning of the 20th century. She was quite impressive, learned a lot of languages, and was, I think, quite a courageous woman. So that's her. And what I found particularly funny was that Fretzi was the nickname of Ben's brother, but also of my brother. So his name is Fritzi as well, so that was quite a funny coincidence. And perhaps an interesting thing that came up during the competition, as you can imagine, this compromise or the statement of agreed facts evolved quite a bit, but in the oral rounds we could still see some remnants of previous versions of the compromise, where we had put different problems in there, but that seemed to have stuck somehow in the fact pattern. So for example, for a while we were thinking of putting the existence of a dispute as a problem in there. So you can still see, I guess, here and there that there are facts that would have led to a discussion of that, as well as the OCDP charter. We had a huge annex where we just made up an entire charter of a regional organization that eventually got quite reduced, but you can still see it, I think. And in the rounds, there was much more importance attributed to it than we had eventually envisaged. And finally, also the fact that crimes against humanity played such an important role also in the pleadings was, I think, due to the fact that until very late we couldn't really decide which crime we actually wanted to put in there, and that was, I think, one of the most difficult issues, how to do that in a way that would flow well with the whole narrative. Right, so I think I should stop here and let you speak, and I'm very much looking forward to that. Thank you so much.
I don't know if
All right, so here's what's going to happen, and we've now done it multiple times that we know the limitations of what's going to happen. So we have about, I have literal people will stand in the back and will kick us out, about 40 minutes to do this. There's a lot of you, not enough time at 40 minutes. So we're going to make this be a very dynamic process. Your questions should be short, concise, to the point, and our authors will do their best to also provide short, concise responses, because from experience, many of you would have questions. So please come, start forming a line here in front of that mic whenever you're ready to, exactly. So while this line is forming, I'll just say one final thing to the people in the room, which is everyone here today participated in a competition that is centered around winning and losing. And I wanted you to just know that the idea of what winning and losing the Jessup Moot Court competition isn't whether or not you won the round that you won or lost in. Rather, winning this competition is exactly the kind of stories you just heard from Janina and Ben, that is coming back to contribute and support this competition, developing networks of affiliation and collaboration that carry with you long term. And it is in that sense that you are all winners, irrespective of what happened in the rounds that you did. So congratulations to all of that. With that, we're starting. So take it away, please.
Hi. Thank you so much for being here. I wanted to ask, is Karen, the nearby state in the Payne Peninsula, is that a reference to the scholar David Karen? Okay.
Yes.
Cool.
I can say that originally, in the original draft, each of the states in the Paine Peninsula had a different name, and we were naming them after ad hoc judges of the court. Then we decided not to do it, but Karen kind of.
Hi, I wanted to ask, why was an extradition treaty created in the clarifications? Because we had to rewrite half of our memo after that.
I think at some point we realized that it would be more helpful to teams if there was an express clarification of that. Before that we had thought that it was kind of clear, implied in the fact pattern, but then in the rounds of questions that were asked by teams, we realized that it was not. So,
But
yes.
the idea was always for the extradition to have existed. We just had it implicitly at the beginning, and then through the request of clarification, it made clear that teams needed for it to be explicit.
Thank you.
Thank you. I want to ask, I noticed that there is not mentioning about whether the enforced disappearance is in the criminal code of Ambrosia. So is it designed or?
It was deliberately designed also to give some way to argue for Robinia that there was a problem with criminal prosecution in Ambrosia.
So if we would have had Ambrosia issued a formal arrest warrant for criminal proceedings, for example, under the crime of kidnapping, which was essentially a mirror crime, it would have made it very difficult for the respondent. So we needed to create all this kind of unclarity or opaqueness around what was actually Ambrosia going to do or not to do.
Thank you.
And also, perhaps just to add on that, it's something that is quite relevant in practice, especially with respect to enforced disappearance, because many states that are actually party to the convention do not have a specific provision on enforced disappearance, but cover it under other criminal offenses in their penal codes. So there's a bit of unclarity how to deal with that in practice anyway.
Thank you.
Good morning. I wanted to ask you, what did you have in mind when you put the reference to the Ambrosian proposal in the negotiations regarding what was inside the essential domestic jurisdiction? Because myself and my teammates spent countless nights trying to understand if it had any relevance at all, and then nothing was mentioned in the oral round. So.
Well, I think if I can...
Yeah, go for it.
If I remember correctly, it was an argument to essentially accuse Ambrosia of cherry picking, because at some point they are asking that they are arguing that this exception or exclusion of jurisdiction does not apply, even though in the beginning they were in favor of actually narrowing the compromissory clause down to exclude these types of offenses. So there was a way of then, accusing Ambrosia of
It was
cherry
basically much more of a policy argument than a legal one.
Okay, thank you very much.
Well, but I will just say that in the version where you had the OCDP charter in full, you had the preambular clauses. In this version, you obviously did not. So that is what I saw, is that it helped teams also argue object and purpose in a way that they could have.
Yeah, true.
Thank you for such an incredible problem. To return to the extradition question, do you think the extradition treaty could conflict with the Disappearances Convention? And if so, how could that conflict be resolved?
So the question is whether the extradition treaty could conflict with the convention.
With the Disappearances Convention, with ICPED, with ICPED, yes.
Right. Well, I don't think an extradition treaty as such would conflict with the convention. I think that actually a way in which you comply with Article 9, Paragraph 2 on the Convention is precisely through extraditions. As long as you prove, obviously, that the state requesting the extradition is actually going to follow through and prosecutes the person and presents criminal charges. So I think the idea of having extradition treaties at a bilateral level, in my view at least, it's completely consistent with the Convention. What is probably not consistent with the Convention, in my view, and this is a different question, is claiming that there are immunities for the crimes under the Convention. And of course, there can be different views, and Janina might have a different one. But at least I always saw the ratification of the Convention as an implicit waiver of immunities.
Thank you very much.
Yeah, I would have a different view on that, but
but no
That's
lex
probably
specialis.
the good bit about it.
You do?
Good morning. Can I ask 2 questions? The first question is, why is Ukraine versus Russia included in the basic materials?
I can answer that. I can answer that.
And the second one is, what is international legal rules on jurisdiction? Like, does it encompass the bilateral treaty? And does it entail a relationship between treaty and custom?
You want to take a sec? Okay. The first one is very short. We included it because it's the latest judgment of the court where the test for jurisdiction, ratione materiae, is established. And it's the most complete account so far by the ICJ on what the court does to determine whether the claims presented by the applicant fall within the scope, jurisdiction, ratione materiae of the treaty. So what we wanted, teams, were not only to go directly to the interpretation of the OCDP charter, but actually to understand what is a substantive issue behind jurisdiction, ratione materiae questions. And we thought that by reading the Ukraine-Russia case, which was not directly applicable to this exception, but it would provide important background information on how advocates should think about objections to jurisdiction, ratione materiae before the court.
Thank you.
With respect to the second question, did I understand it correctly? You're asking about what the law on jurisdiction.
My question is actually because the submission concerns the claim of violation of international legal rules on jurisdiction, and we were very confused about which legal rules are contained within this reference.
Right. This was mainly a reference to customary international law on the exercise of jurisdiction. With respect, I think this was one of the most challenging bits that we discussed also extensively with the editorial committee on how to formulate those final submissions of the respective states, because on the one hand, we didn't want to make it too easy for teams to identify the legal rules that they have to examine. On the other hand, we wanted to give some guidance, so the formulation here is sort of a compromise solution that should give a hint as to where to go, but also not be too easy for teams.
Thank you.
Good morning. I also have 2 questions. The first one is, how big is the actual area of Triton Show within or without the Ambrosian economic zone? I understand that I've made some calculations, and even under very generous assumptions, it's very small, which I actually think makes the point C very realistic in that it's like a fundamentally jurisdictional dispute and not a dispute about who caught the fish there. But I want to know how big, in your mind, the actual area is.
So, I mean, we actually have never talked about this. So it was very deliberately left in indeterminate terms because we did not want teams to actually engage at all with the size of the Triton Shoal, how much was, in the high seas or the exclusive economic zone. I personally always thought it was quite small. I didn't think that it was actually that relevant in terms of economic activity. For me, it was more about the legal rule that was involved, regardless of the economic impact.
Yeah,
I don't know.
I agree.
Yes, thank you. And the second question, which I guess would actually be more addressed to Mr. Pavlopoulos, who unfortunately, I guess to everyone's regret, isn't here. But why didn't Ambrosia challenge the impoundment of the aircraft in the first place?
Oh, well, no, we can answer that.
Yeah. and not the, because the prayer for relief is structured in that the seizure and sale subsequent to the waiver of immunity by the Transitional Council is what's being challenged and not the impoundment.
So this was a huge issue. I would say that if I would have to identify the major issues that we discussed as authors and with the editorial committee was how to frame issue 4. And I'll let Janine elaborate more. I just want to say that the problem with issue 4 is that we did not want teams to engage in questions of immunity. We wanted teams to engage in questions of government recognition. So the issue was, how do we protect the pleading? And maybe we went too far in protecting it, and that's debatable, and maybe we can have self-criticism for that. But the idea was how to protect the pleading so it discusses government recognition. So by phrasing it in those terms and linking it to the seizure and the sale and basically the waiver, then teams would actually know that they had to focus on whether the waiver was valid, which is a question which underlines the government recognition issue. If we went back to the impoundment, which was a pre-waiver impoundment, then teams would have to engage with questions of immunity. There was no other way without engaging with immunity. So impoundment was a way to exclude immunity from issue 4.
I have nothing to add. I mean, it would have been a different sort of claim 4 if we had included it, which would have raised very interesting questions as well. Eventually, it was not an issue taken motivated by substance, really. It was more like where to put the emphasis. Because if we had included it, it would have raised interesting issues also about retroactivity of a waiver, which could have been explored as well, quite interesting. But eventually the decision was taken that this claim should really be about identification of government, and that's why it got excluded.
Thank you.
Just asking that we limit ourselves to one question each, just because the line is very long, and I want to give as many of you opportunity to ask your questions.
Thank you very much. As I kept reading the case, I think I started saying once or twice every week, God damn, these are good damn lawyers. Because you were writing specific words saying the narrative was very good. An example is paragraph 61, in which a pilot's complaint for enforced disappearance, but never is saying that an arrest warrant was issued for enforced disappearance. That's a very technical point, very good lawyers. Just to reduce one point, however, for me, it was a good choice when you went and changed the ambulatory Ambrosian lines to just normal baselines with clarification 2, but it seemed like a correction, but that's the choice, it was good. But the one thing that has troubled me all the time is clarification 3. How is it that a chart presented for the first time, it can depict ambulatory baselines? You got me, the team, to decide what is a large-scale map, 1 to 2 million, 1 to 300,000, whatever. At the end of the day, just one line in a chart. How can one single line depict ambulatory baselines? I mean, when you get a second chart, you get to compare. You made us go into ICLOS and ICJ. ICJ maps only go to degrees. ICLOS go to minutes and seconds. There you can see a difference, but it's still one line. With no previous line, there's no comparison to identify the ambulatory.
It is a snapshot, after all. I mean, but also for ambulatory baselines, you would have a snapshot of the line.
But it is the first chart that was presented, so therefore it's no way to identify the past.
True, yeah.
No,
okay.
I think we agree on the technical point. I think the overall idea of that part of clarification 3 was to use ambulatory baselines as opposed to fixed baselines, obviously.
Yes.
But I think you're right from the technical point of view.
Good morning. I have a question with regard to the most controversial point on law or fact within your team that you could not agree on. So you 3 have different opinion on matter of the compromise or the law itself within this year's matter. The most controversial one that you have different opinions on.
Well, we have different opinions on issue 4. So Nico speaks for himself in his books, but I think everyone knows how Nico feels about government recognition. I don't agree with his views on government recognition. So I think that's a substantive point. But I'm going to say that as authors, at least for me, the fact that we thought different on substance was never an issue for writing the case. Because it was actually good, because it allowed us to improve the actual drafting of the compromise. The more difficult part when you draft together is about which parts to prioritize, where to put the emphasis, how to exclude certain parts from the case. This is the more challenging thing as an author. Having different views on substance is not difficult.
I would agree. I mean, in particular, where to put the emphasis. So some of the author's team would, for example, think that the emphasis should be put, or the focus should be put on one aspect, while others would want to expand the entire claim to cover more avenues. So I think if you look at the submissions, you see that there are some submissions or claims where you could go into very different directions. There are multiple avenues you can take. Other submissions where there's which are more limited, and there, I guess many of us would have perhaps broadened it a bit. But yeah.
I'm not a party to this debate.
Thank you.
Hi, good morning. I wanted to ask you, because Article 21 of the OCDP Charter is awfully similar to Article 31 of the Pact of Bogota, which...
Yes, it was modeled after the Pact of
Yeah.
Bogota.
Yes, and it has been argued before the International Court of Justice to be an optional declaration in the Honduras and Nicaragua case. And it is an optional declaration made by way of a treaty, which is somewhat controversial. So I was wondering if that was a discussion that you intended members to have, or if I just fell into a research rabbit hole for no reason.
I mean, we were aware of this ambivalent nature of that provision. I think we always considered it as falling under Article 36, paragraph 1, and not so much as a sort of collective unilateral declaration. But it should not have featured as a major point of controversy in.
What's interesting is that that part of the compromissory clause was drafted based on the Pact of Bogota, but the exceptions were drafted based on declarations to Article 36, paragraph 2. So we got inspiration from different parts into creating the OCDP compromissory clause.
And also, I think, if I remember correctly, it came in relatively late at the drafting process, because for a while we had also considered introducing some sort of jurisdiction rationa materia discussion, and that would have been a much more limited sort of compromissory clause. And eventually, when we took the decision not to have a jurisdiction rationa materia aspect, we looked for a compromissory clause that was extremely broad and general. So that's how it came in.
Thank you.
Hi. So 2 questions, if I can. So one was, we entered into a rabbit hole as to who the authors were. Benjamin, we sort of knew you were one. And we also considered that Massimo Lando, who has written with you and Nico, was probably an author. But besides that, so for the exceptions, the temporis and materia exceptions, did you realize that Rovinia was arguing for Claim B, but that C and D should have been excluded if you were, let's say, making temporal arguments? Claim C was excluded, and the judicial proceedings, essentially domestic, for Miss Cross, and the impoundments were also sort of similarly arguable. So we wonder whether you took that into consideration, because it made Rovinia look a bit, let's say, not doing the same for the different arguments.
So definitely one thing that we did want to show was the contradictions in which states find themselves when they argue before the court. And here you had Rovinia saying there's no jurisdiction, but at the same time saying I want to exercise universal jurisdiction, right? Which to many of you would have been like, wait, what's the consistency of this? And we talked about it a lot, and it was on purpose, because states a lot of the times have to stand before the court and make claims on jurisdiction and on the merits, which on the face are not completely consistent. So it was part of it.
Good morning, and last year after the final, Michael Pyle gave us spoilers to each of the issues, and issue 3 was, he said, fisheries. But of course, in most part of our submission, we did indeed regard the interaction between the laws and the sources of the law. But so, did we not have to look into fish and yellowfin tuna at all? Because we did, we got into UN fishing stocks agreements. We checked the annexes because the spoiler was fisheries, and we were like, yeah.
I think it was really more of a fact pattern spoiler, not so much with respect to the legal issues.
Right. The idea for the spoiler is not to tell you exactly what the case is going to be about.
But yeah, for issue 4, it was validly about whether the government was, and for others too. So, but anyway, thank you, because we also now know about the tuna species, I guess.
I'm glad you learned about tuna.
Thank you.
Good morning. My question was with regards to the Transitional Council. So we know that in July in Bangladesh, there was a massive uprising by students, which led to a very similar revolt, and then the former prime minister leaving the country, a new Transitional Council forming. So when we got the problem, we were like, oh, this is actually what is happening with us, because I'm from Bangladesh as well. So did you have any reference to that or any other particular uprising that led to the formulation for this part?
I think when we thought about it, we didn't have one specific incident in mind. I mean, there was, of course, the situation in Venezuela that was also quite inspiring for this sort of issue, but interestingly with this sort of legal issue is that, as we've seen also last year with respect to Syria, for example, is that it comes up all the time. And very often the same sort of constellations are showing up in different places of the globe. So, I don't know if you...
I will just say that when issue 4 was not tailored to fit one situation in the world, but it was taking into account generally the question of how government recognition is playing simultaneously in different parts of the world.
Yes. One small question. So you guys have also mentioned that Ms. Cross had a long-term visitor visa. So did that actually help us in any argument? What did you guys have in mind when you wrote that particular line?
So we had to strike. The idea was for you not to go into that. So the long-term visa was basically to tell you she doesn't have dual nationality,
yes,
which would have raised other questions of jurisdiction. And if she was just there as a tourist, it would have maybe given more reason, it would have strengthened the arguments of the applicant. So I think the long-term visa was saying she's legal, she's there, but she actually is not a citizen of Romania.
Thank you very much. It was a pleasure.
Good morning, and thank you for your work. So the question is there any possibility that the present issue concerning issue 2 is actually outside the purview of OCDP Charter? Because despite the clear wording that Article 21A, the wording is that the ICJ has the capacity to entertain all juridical disputes, but actually in the preparatory work of the OCDP, actually the members only intend to submit to address the issues concerning sort of like drug dealing or armed trafficking, these transnational crimes. But the present disputes under issue 2 is actually only concerns interests of 2 states. If I could say that, since this is a matter essentially concerns which states can exercise jurisdiction. So is this matter really a matter that the party intended to address under the OCDP? And if not, how can the parties intend to submit this dispute to the ICJ if they do not intend to address this issue under the OCDP? So is there this possibility that despite the clear wording of Article 21A, actually the juridical dispute should be limited to the dispute that the party intend to address under the OCDP Charter, which is some sort of issues relating to transnational crimes, or at least the crimes or matters that concerns multiple interests, the interests of multiple parties among the members of OCDP. Is there any possibility of that?
So you mean that perhaps the OCDP arrangement should have priority over resolution through the ICJ, or
actually, is there so the OCDP could possibly have a rather limited capacity, or the sphere of the compromissory clause of OCDP is actually limited to the transnational crimes.
I see your point. It's about whether, if I understand correctly, it's about whether we should read the compromissory clause of the OCDP Charter in light of the other provisions of the Charter, and whether that constrains the jurisdiction of the court. Yeah. I mean, it's a possible interpretation. I think that the language of the compromissory clause is broad enough, and it was intended to be broad enough to be able to include all kinds of disputes. And I, at least personally, I don't think that the question concerning Ms. Cross is so far removed from the OCDP Charter as to claim that it could not fall in any way under the umbrella of the Charter. I agree that under Article 1 of the OCDP Charter, it's not clear under which of the 5 purposes listed there the question of Ms. Cross could fall, and that's a point. But I think that given the broad way in which the compromissory clause is drafted, and because the OCDP Charter is still a broad regional organization, it would be very difficult to exclude the court's jurisdiction on that basis.
Yeah, that makes sense. And another one small
we just have 7 more minutes, so I want to make sure we get.
Thank you.
Hello. Yes.
Hello. So I just had one question in regard to the clarification about. So Ambrosia did not update its baseline since 1999, which would mean that it, by not updating its chart, it had frozen its baseline since 1999. But then it brought a freezing law in 2015. Our team had a week-long discussions on why did Ambrosia choose to freeze the 2015 baseline if it actually had frozen its baseline since 1999, which would actually be disadvantage for that. We were like, are we missing out something, or is it supposed to be like that? It was like a week-long discussion about this.
I see.
We definitely discussed a lot about the updating of baselines, also because at some point we realized that we should make it clearer how exactly we imagine the coastlines to look like and how exactly this would develop over time. But I don't think that we had a week-long discussion about this, if I remember correctly.
No, I mean, we were trying for teams not to engage too much on the obligations or non-obligations under UNCLOS of updating charts. So we wanted teams to focus on the substantive discussion on whether baselines can be frozen in light of sea level rise, rather than more procedural obligations under UNCLOS, which by the way are debatable, on the updating of charts. So I think the purpose of the clarification was to try and signal teams don't go into charts, but go into the substance of freezing baselines.
Thank you so much.
Maybe we failed at doing so, but that was the plan.
Good morning. I wanted to ask a question about the force issue with regards to, because we had to make arguments on legality of the government and also the effective control. But I wanted to ask whether you think there is indeed a duty even to recognize some government, because it seems to go against the notion of non-intervention in international law.
Well, I mean, I'll let you answer, but I just want I think here we purposefully linked the question of government recognition to certain action taken, which was the seizure and the sale of the plane, so that we wouldn't go into a different discussion, which is whether government recognition as such creates, is a duty or can constitute a wrongful act or so on. So by linking the recognition with action taken on the basis of such recognition, we left no doubt that the government recognition had to be assessed, the legality of the government recognition had to be assessed because it was linked to a specific action taken on the based thereon. And of course, there are very different views, and both of them with very valid arguments on the two theories put forward for government recognition.
So basically it was linked to UNCJSP, right? Only with regard to the recognition with the waiver, whether it was authorized act of state, right?
Right. So we were not expecting teams to engage on whether there is a duty under international law to recognize governments, or whether there is a duty in international law not to recognize governments, which is obviously an open question. So we included the seizure of the plane precisely to avoid that question.
Oh, okay. Thank you so much.
Yeah.
Hi. So with just those two instances where Romania did not object, how long did you expect teams to stick to their gun and say Romania is not a persistent objector, or did you rather expect them to argue some sort of a jus cogens exception to the persistent objector doctrine?
Well, I think the persistent objector part was one of the most interesting parts that we thought to include in this statement of agreed facts, because it's such a controversial notion, and especially if you tie it to regional custom, I think it is one of the unresolved issues in general international law, in particular with respect to customary international law. So I think, yeah, you could probably spend the entire 90 minutes just discussing that. I don't know if you want to add anything.
Thank you.
Hi. So first of all, thank you very much for writing this amazing statement of facts. You gave so many people a great opportunity to learn so much. So thank you so much for that. One question about whether some problems were hinted at in the statement of agreed facts that I've annoyed my team very much with, that I wanted to ask you if they're actually in there. The first is like a broader jurisdictional challenge, not only on the first, but also on the second and third issue. How you could interpret, for example, the unilateral declaration of Romania that they agreed to the jurisdiction, or if that even has value, for example, with something like the monetary gold exception. And the second one, if you wanted to hint at the right of territory in the context of decolonization by including the colonial past, sort of like the court recognized in the Chagos and occupied Palestinian territories. Advise your opinions.
I can take the first quickly. Okay. So regarding the first question, I think this is a bit of what Janina was referring to earlier on the remnants of the earlier versions. So the questions of jurisdiction really changed a lot during the process. Initially, as we had fleshed the entire OCDP charter, basically all questions of jurisdiction were ratione materia. So we had a jurisdiction clause similar to the one that you have in the Genocide Convention and the Torture Convention. So for each claim, teams had to be prepared to plead whether it was a question of interpretation or application of the OCDP charter. That didn't prevail. Then we also thought about including admissibility issues. We did not think about monetary gold, but we wanted to include a question of reverse compliance request, which was present in the last Ukraine-Russia case as a question of admissibility rather than jurisdiction. We played a lot, and at the very end, because at the very end, you can have a lot of interesting legal questions, but you have to make the problem mootable, right? And one of the great things about working with the editorial committee is that you as authors come with, a lot of ideas, and the editorial committee has the experience where they tell us, well, this actually is not going to be realistic to moot. So we decided purposefully, and this was great guidance from the editorial committee, to restrain the questions of jurisdiction only to one pleading and expressly leave the other two outside. But if the problem gives nuances or signals in the contrary, it's probably part of how a draft evolves from when it's first written until it's published.
Yes, I mean, I can only add that I think the first claim is the one that evolved the most over time. And with respect to the second question you asked about the potential colonial issues that we wanted to include, I think this is also a remnant from very, very early discussions we had when we actually included information also about the two people belonging to different ethnic groups that came from a colonial past and that were also in this sort of claim 4 issue about recognition of governments and of civil uprising, but eventually we decided to exclude it because it would have been a bit too much, but it's still in there, yeah.
Thank you very much.
All right, so just a point of order. So the next question is going to be our last question, just because I have people in the back. But wait, all of you people standing in beautifully in the line and waiting, the authors will still have about 15 more minutes to talk with you, 10 to 15 more minutes to talk to you. It will just have to be outside of these doors because this room is going to be set up for the final round, and that needs to start precisely at 12:15. And so we'll take this final question, and then all of you, please just meet us all outside. But please, go ahead.
Thank you. Thank you for the case as well. It was a really nice case to discuss. I was wondering about the question of the especially affected doctrine in regards to submission C. In regards that we can see there are some hints of a especially affected doctrine there. However, from my research at least, it's not a very recognized and applied doctrine. So I was wondering how would that apply in a question of a regional custom? Because when you talk about a regional custom, it's a very narrow region, of course. And I was wondering whether or not this would be applicable at all because we see that Ambrosia has been suffering more of sea level rise. However, Rovine is more affected economically by the yellowfin tuna. So I was wondering what were you guys thinking about that? Thank you.
I can take
this.
Yeah,
of course.
I think the reason here was that we wanted to allow for different avenues to be taken with respect to that issue, and the specially affected states aspect would have been an aspect that could have been raised when you would be discussing if there's a general rule under customary international law that would allow for the fixing of baselines for specially affected states. So that would have been an argument separate from the regional custom argument, although the same sort of facts would appear in different argumentative forms in those respective avenues. So either especially affected states or as a group of regional states that are bound by this particularity.
Thank you.
Okay, with that, please join me in thanking our amazing authors for this incredible talk.
I think we survived quite well.